Welcome everybody to our Constitutional and Administrative Law Study Series. Now, just like with all of the other study series, what we're going to be doing in this lesson is taking a revision guide study approach to looking at some of the basic principles of constitutional and administrative law. This lesson and the next lesson is going to be free, and so it's available for everybody so you can get an understanding of what the kind of things that we do with these lessons look like. For the rest of the content, and for the rest of the content of the other study lessons for the other subjects, in addition to having early access to every other lesson that we do on the Law Academy, go pick yourself up a level 3 membership. It really supports this project. It really supports this channel, and you get these study videos for that as the result of your support. So hopefully I'll see you in the members only videos. But for now, let's just take a look at this topic in more detail. This topic is on the UK Constitution. So the previous lesson, the previous study video looked about the nature of the Constitution as it exists in its generality, i.e. what does it mean to call something a constitution, what actually is a constitution, how do constitutions work, what things actually have constitutions. All of this has been the subject of previous study videos. This lesson is basically going to take the basic ideas and the basic principles of the nature of a constitution and apply it to the UK system. And so we're going to explore the basic structure of the UK Constitution in this video. And I want to begin by talking about the idea of amending a constitution. So towards the end of this lesson, towards the end of this study video, we'll talk about something known as comparative constitutional law, where we can make comparisons to other constitutions to look at where they are similar and where they differ, where they are better in some areas and where they're not as good in other areas. And we'll look at the process for making an amendment to the US Constitution versus the UK Constitution, and the kind of principle that actually enshrines. And it should just be worth noting at the outset that the UK Constitution is relatively unique in terms of its structure. As noted in the previous study lesson, the UK Constitution is what we describe as uncodified. And what we mean by uncodified is that it does not exist in a single document. It is not written all down in one place. You should not get this confused with the idea of a constitution being unwritten. The UK Constitution isn't necessarily unwritten. Plenty of parts of the UK Constitution are written down. It is just that they are not all written down in a single place, in a single document. They are not codified. Other constitutions of this nature include New Zealand and Israel, but for the most part, this is a quite rare system of constitutional law. For the most part, when you study a constitution in a different jurisdiction, like in Germany or in France or in the United States, you are often dealing with a codified constitution. And one of the things that distinguishes a codified constitution from an uncodified constitution is the changing nature of the constitution, the way in which we are able to make an amendment to the constitution. Now, one of the basic ideas that this essentially levies is that a codified constitution is often difficult to amend. It's difficult to essentially change things about that written document because often it is the case that within that constitution there is a process for amendment. So, for example, I believe it is Article 4 of the US Constitution deals with the process of amending it. And it's a very arduous and difficult process. In the United States, an amendment requires a 2/3 majority in Congress and a 3/4 majority of the state legislatures, which essentially requires both 66% support in the legislature and then 75% support across the state legislatures, which is a ridiculously high bar, high standard, and high threshold that it would be inconceivable that any idea, any provision, any understanding of the Constitution would would be able to be attracting that level of partisan understanding in the way in which the United States operates to this day. So this is the reason why the Constitution has only ever had 27 amendments in the United States, with the first 10 of those being the Bill of Rights. So outside the Bill of Rights, there has only ever been 17 amendments to the US Constitution. Because it's therefore so difficult to amend, it is a very entrenched, very inflexible document. Whereas the UK's constitution is relatively easy to amend because it is not codified, because it is derived from a variety of different sources. It is actually the case that the UK constitution is always amending itself. It is always changing in really minor, little, small ways, and then maybe when there's a big Supreme Court case, it will change quite significantly, or when there's a big passage of some significant legislation in Parliament, that makes a huge difference to the Constitution itself. And that's really as simple as it is. The passing of a judicial decision, the change in an existing constitutional practice, like a constitutional convention, or a new law enacted by Parliament, or a repealing of a law enacted by Parliament, all are methods by which the UK Constitution can change. And at least when it comes to Parliament, this requires a simple majority. Parliament could tomorrow repeal the Human Rights Act or repeal the Constitutional Reform Act and get rid of the Supreme Court and take us back to the law lords, the system that we had prior. All they would need is a majority in the House of Commons and support in the House of Lords. That could be done in a week, okay? Amending the US Constitution, by contrast, is far more difficult. So with that being said then, let's look at the basic structure of the UK Constitution. And one of the things that's really, really important about constitutions is this idea of there being a separation of powers. The idea of a separation of powers fundamentally speaks to the nature of state authority and the nature of the fact that there are different powers that different institutions of the state can essentially do. And it should be the case that the state separates those powers out, such that the people and the institution that is responsible for making the law should not be the same institution as the institution that is responsible for interpreting and applying the law. Or both of these should not be the same institution as the institution that is responsible for the enforcement of the law. And this is really where we see in a variety of different systems around the world the idea of the separation of powers. The separation of powers is therefore divided often in a constitutional system into three major branches. You have firstly at the top here the legislative branch. The legislature is responsible for, as the name suggests, legislating. It is the institution that is responsible for the making and the passing of law. This is situated in the UK system in Parliament. The executive branch is the institution that is responsible for executing the law, for the execution of law, for the enforcement of the law. Okay, this is found in the UK government, which is headed by the Prime Minister. And then finally you have the judiciary. The judiciary is responsible for interpreting and applying the law. This is, of course, found in the various different courts up and down in England and Wales, and also across the United Kingdom, and is situated in its highest form in the UK Supreme Court. Now, in other systems of government, in other systems of the constitutions, okay, you see that there is a clear and distinct separation of powers. Okay, so for example, in the United States Constitution, each of these branches, the legislature, the executive, and the judiciary, are very, very clearly separate. So, for example, the legislature at the federal level in the United States is found in Congress. Congress is the House of Representatives and the Senate, and they are responsible for the passing of law, for the making of legislation. The executive, by contrast, is the White House and the presidency. They are responsible for executing the law. They are responsible for enforcing the law. The executive and all of her departments are responsible for that. And then the judiciary, which is represented by circuit courts and the Supreme Court, are responsible for interpreting that legislation to ensure that it is constitutional, that it is able to be applied correctly, but also to be applied in a way that is in line with the US Constitution. These are clearly separate institutions, okay? You do not ever have a situation in which the President of the United States is able to pass legislation in Congress. That is not the role of the President. The role of the President is separate from the role of Congress, okay? And within the US constitutional framework, you have a variety of checks and balances, which essentially means that each of these three distinct branches has the authority to have power over the other branches to ensure that no one branch gets too authoritative, gets too powerful. So, for example, the United States, when it comes to Congress, they have the ability to pass laws, but it is up to the president to be able to ratify that law, to essentially stamp their seal of approval on that law. If they choose not to, they can veto it. That is an example of a check on the Congress, a check on the legislature by the president, by the executive. And then by contrast, if Congress disagrees with this veto, they can override the veto with a 2/3 majority. Again, this is going to represent something of a check on the presidency, on the executive by Congress. So that's how the system works in a sort of nice, neat way in the United States. Doing some comparison then, the structure of the UK's separation of powers and constitution is very, very different. So, for example, we do not have a complete separation of powers in the United Kingdom. We have what is known as a fusion of powers between the executive and the legislative branches of government. This means that the Prime Minister and the government, all of the ministers of state, sit in Parliament and are recruited from Parliament. They are MPs, and they pass legislation in the same way that the rest of Parliament passes legislation as well. They are still separate internally, in the sense that Parliament has the role of holding the government to account. When the government, because the government often has the majority in the House of Commons, they are responsible for the setting of the agenda and the setting of policy. It is the rest of Parliament that is holding that executive branch to account within Parliament, but they are not separated in the sense that they sit in different chambers or they sit in different institutions. In fact, they are fused together. Prior to the Constitutional Reform Act, it was also the judiciary that was part of Parliament as well, at least the highest point, sitting in the House of Lords. These were known as the Law Lords, and it was the 2005 Constitutional Reform Act and the subsequent 2009 opening of the Supreme Court in the UK that sort of put some blue water between the Supreme Court, which is now situated in the old Middlesex Hall, and Parliament, which is obviously still situated in Westminster. So it's just a very interesting thing to note that there's a lot of unique elements of the UK's constitutional framework. We're going to start to unpack a variety of different principles of the UK Constitution over the next few lessons, as well as looking at the structure of the UK government before looking at some of the basic ideas relating to the separation of powers. We'll do that in a bit more detail, the rule of law, parliamentary sovereignty, devolution, and the relationship between the UK and the EU, the relationship between the UK and its human rights obligations, before then moving on to the administrative side of public law, which looks at the idea of judicial review and police powers and these kinds of administrative operations within the UK's constitutional system.